afternoon, and welcome to AIADA's AutoTalk. I'm your host, Rachel Soleimani. Today's webinar is sponsored by Federated Insurance, an AIADA affinity partner for over 25 years. Federated is committed to helping AIADA members find value in their insurance and risk management programs. Now, for a few quick reminders, anyone that is registered for today's program will be receiving a copy by the end of this week. And if you have any questions, feel free to enter them into the Q&A bar in the lower right-hand side of your interface. Now, please join me in welcoming Robin Simons, co-managing partner of the Miami Gordon & Reese LLP office, and Erica Storm, DIWAVE's in-house counsel and an attorney focusing on employment and employee benefits law. Robin and Erica, I know you have a lot to go over today, so I'll let you take it away.
Thank you, Rachel. This is Robin speaking, and we're going to move fairly quickly. We have a little disclaimer here because we want to make sure that everyone knows the limitations of this webinar, and this will be included in the slide deck that you'll receive later. But I'm not going to read it since we have a lot to go over. This is my bio, and that'll also be available to you. I've been working with small and mid-sized businesses for close to 40 years. I grew up in a family business, so I feel your pain, and I've been on the back end resolving some issues relating to employment claims for most of my career. And I like to focus now on what we're doing today, which is being on the front end and trying to prevent them from happening. Joining me today, I'm very excited that we're doing this together, is Erica Storm, who, as Rachel mentioned, focuses on employment and employee benefits law. And in her current capacity as the Director of Legal Content, Erica literally has a national view and the pulse on the nation with regard to what issues are bubbling up. She's on the front lines of questions that come in. So she's able to bring a lot to the table, not just in terms of how things resolved at the end of the day over things that happened 2 years ago, which is really, where litigation kind of sits, but on what's happening with employers today. So we're going to split up our seminar today and talk about how automotive industry leaders can reduce the risk of employee claims, primarily of discrimination, unlawful harassment, and retaliation. Also, we'll touch very, very lightly on a few of the related claims like wage and hour. We'll give you a few war stories today from real life scenarios, keeping in mind our short time frame. And we will also take questions, and we've worked out with Rachel a way to capture the questions so that if we don't get to all of them, we'll be able to review those later and either provide some follow-up or build those into a further webinar. So let's get started right away. The top 5 flashpoints defined. I can spell it, but I can't say it. Top 5 flashpoints defined. What are they? These are the recurring themes and issues that we see. We are focusing on the automotive industry, but I will tell you that a lot of the issues that you're seeing are also being seen by employers in other arenas. Employers, for example, may not have had any remote positions previously, and they have experimented with having some back office functions during the pandemic, but weren't really comfortable and called everyone back. I don't know if many of you are facing this, but many of the employers that we work with are facing this exact issue. And some of the employers that we work with have terminated employees who refuse to come back to work without engaging in much of an interactive process or without documenting that. So we try to give you takeaways that don't cost any money. And this example provides one of those, which is if you are facing this type of an issue, even if you think the employee's request is ridiculous or couldn't possibly pass muster with management, it's important to do the dance to engage in the interactive process with regard to any accommodations that they are requesting in this arena under this sort of umbrella of topics, because that way you have a track record if you are later, or your organization is later accused of having unlawfully not provided an accommodation or provided some benefit that the employee is allowed under law. So documentation is always important. You hear that from any of us that talk about these issues, but also engaging in the interactive process is becoming increasingly important. It's an effective tool when used consistently and fairly. It also helps to show consistency in your application of the policies and procedures that your organization already has. Erica, do you want to talk about topic number 2, attendance and performance management?
Sure. Thanks, Robin. Hi, everyone. Really happy to be with you today to talk about some of these top 5 issues you're facing. So the second issue we wanted to highlight is that of performance management, including attendance. So again, this is something that employers across all industries deal with, and they deal with all the time. We're constantly kind of managing the performance of our employees. But the last few years have really brought up some issues that we are tending to see over and over again. And the fact that we are kind of, as we've labeled it on this slide, we're making some of these decisions very quickly. We're having to be maybe more reactive than we've had to be in the past because we might be in crisis mode for various reasons. Of course, starting in 2020, we were in crisis mode due to the beginning of the pandemic. Since then, we've had, staffing issues that employers are seeing. We're dealing with supply chain issues across different industries. So the various crises of the day that's affecting us may depend on a number of factors. But if we're having to quickly make decisions, what we're seeing is that in some cases, employers can maybe skip over some necessary steps, and some things can get lost where we can run into more risk of claims from employees. So a couple of examples that we have highlighted here on this slide is, maybe we had to implement some new technology, whether it's because people are moving to working remotely, or it's something that we had to do for our operational purposes. And we have an employee who's worked with us for a long time who is just not able to adopt this new technology, or they're really struggling, they're slowing things down. So maybe we made a decision based on that. We are not seeing the performance we need to see. We had to terminate this employee. Another example, so I'll talk about the solution because they're kind of similar for both of them. I'll talk about that at the end, but I wanted to mention this other example first, is that we had an employer remodel showrooms during the pandemic. So there might have been a number of reasons for that. And if we, have seen that across employers, maybe for pandemic protocols, maybe just operationally, we needed to set things up differently. And we needed to relocate employees to a different part of that workspace. But we did it, we're kind of in a rush. We're being very reactive. We're not necessarily doing an analysis to see what different categories of employees might be affected by our decisions for those business purposes. And would there be an impact on those employees? So kind of what we need to do here is, again, similar to what Robin was just talking about. We need to think about, is there any sort of interactive process we need to go through? So will employees who are moved around in their workspace, do we have someone who has a disability? Maybe we need to work through this with them to see if there's an accommodation to be made for where they need to be positioned within the property. If we have a longtime employee, is that someone who's in a category where they're going to be protected based on age? We, of course, can still have our performance standards, but we need to make sure that we're not looking at a situation or making comments or saying, you're an older employee, you can't learn new things, and, you're too old for this position. So we just need to be careful about that. And before we make a final decision about things, we need to just really take a step back and look at the trends that we're seeing within some of those decisions. And are we impacting certain groups of employees more than others? And are we looking really at the performance and any specific issues that maybe can be coached up? Or are we kind of making blanket assumptions, based on different groups that would have some legal protection? So those are some things to think about there.
Thanks, Erica. We've also noticed that in recruiting, especially as the applicant pool has become something of a challenge for employers, that especially in organizations in which there is, let's say, a longtime founder who's still in the business, or longtime leadership who really are looking, to take this opportunity to take the organization to the next level. We've seen a slight increase in the number of employees that were sort of parachuted in where someone in leadership kind of came over the top to fill a position. And so the applicants didn't come through the normal pool from which the organization hires. And then later on, there are some performance management issues, and the organization sort of looks back and they kind of have an uh-oh moment because they didn't really follow their own procedures and policies in the hiring process to start with, because they were trying to fill a need and because someone was coming in with a solution that looked really good. So it's not a glamorous idea, but what we found is that the employers who navigate that sort of a situation best really lean into the policies and procedures that they already have and treat it kind of like one would in an infectious disease ward, by which I mean follow the script, follow the policies and the procedures for onboarding, for hiring, for marketing jobs. I'm not saying never take anyone that's presented as an over the top and down in type of candidate, but don't suspend all the other policies and procedures that you have. And also, if that's happening on a fairly regular basis, it's probably good to do a look back, which is part of what Erica's slide here talks about in terms of analyzing surprising trends. If that's happening significantly in your organization, you just want to look and make sure that your policies and procedures around, not discriminating against against anyone for an unlawful reason are still being complied with, and that you aren't inadvertently or accidentally creating a situation in which the organization could be criticized. So let's move on here to topic number 3, which is workplace safety. We've seen a lot of issues lately around the issues of employee to employee conflicts and employee to customer conflicts, sometimes customer to customer conflicts over PPE, primarily over masking and over vaccines and boosters. Some of these are just basic civility issues and are somewhat exacerbated because of the degree to which they have in recent times had a bit of a political tint to them sometimes. And against this, and this next bullet might be a little surprising to you, but we really think that there's a connection between the way people respond to one another around issues of PPE and vaccines and the trends, which don't seem to be entirely connected, of relaxation of laws regarding lawful recreational and medical use of marijuana and other cannabis products. The real underlying, I guess, common thread here is that there have been fundamental societal changes in people's expectations about what they can personally do in and out of the workplace and what they should be expected to tolerate from other people in and out of the workplace, and the degree to which the employer has anything to say at all about what they do outside the workplace. So all of those issues are really, we're seeing a lot of claims that are related to just those issues. And one of the examples we thought is probably something that many of you have seen is a customer baiting an employee for wearing a mask after the mandates were relaxed. We've probably all seen someone speak to a stranger and feel entitled to criticize that stranger's choice of wearing a mask. So managers all across the country are dealing with this, and some of the claims that we've seen lately have resulted when the manager was in sort of a customer service mode, and regardless of their training or their personal feelings about it, apologize to the customer on the basis that, hey, the customer's always right, I want to make this sale or want to facilitate this sale. And then the employee felt unsupported. And if you take the mask piece out of this and you just say that, for example, the customer was rude and the employee felt unsupported, the difference between how this rolls out now and how this probably would have rolled out 5 years ago or 10 years ago is that 5 or 10 years ago, and I'm speaking in a very general sense, but there was a greater chance that the employee would still feel part of the organization and that they were unfairly treated, but that the organization's goals were what determined how the manager handled the situation. Employees now, in greater numbers and to a greater degree, seem to feel that their own comfort level or perception of the degree to which they are supported is equal to or exceeds the organizational goal of customer service. That's a really difficult issue that almost all employers are navigating right now. And this next part of the slide says solution. It's a solution. I should have put an asterisk there because I'm not sure there is one solution or a solution. But in terms of risk mitigation, which is what we're talking about today, what we recommend is that organizations train managers in advance to manage these types of dilemmas, arm them with specific phrases, and this next part is probably even more important. Set expectations among employees so that they feel supported in advance, so that they are not taken up by surprise when it happens, because this is now predictable conflict. So the best thing you can do for right now, under the current circumstances, is to train people and to reduce the element of surprise so that people are acting less ad hoc when it does happen, and that they have a comfort level as to how the organization is going to handle this type of a dispute after it has occurred. Sometimes an after-action dialogue is necessary, or an after-action conversation. But if you do the training piece on the front end, a lot of these situations seem to be a little bit less messy on the back end. So Erica, would you like to talk about topic number 4?
Yeah, absolutely. And this topic, that of classifying employees or misclassifying employees, is something that we see a lot here. We get a lot of questions about the different aspects of making sure that you classify employees correctly, which really fits the theme of trying to avoid risk and avoid liability. So we want to make sure that we take actions on the front end to comply with the requirements for either having an employee or having an independent contractor, to make sure that we're doing that right, so we don't end up down the road with having made a mistake and then having consequences come back to bite us later. So this is really something I think that has come up a lot because of this development of what is known as the gig economy, where individuals, maybe in addition to a regular 9-to-5 job or instead of a regular 9-to-5 job, are kind of working these different jobs. And I think the most common examples would be like an Uber or Lyft driver, or someone who is, delivering groceries or food or things like that. Like through, DoorDash or some of those other really big name companies that have these types of workers where they kind of just take on those jobs as they can. So we may see, those types of job as well. The example that we have here is some of the dealer trade drivers, like auction drivers or the dealer exchange drivers that we, might have contracts with in this type of industry. But regardless of the industry or the type of employer, there is a lot of attention on compliance with the classification requirements from the EEOC, also, the IRS, the Department of Labor. They also get really involved in this because employees are treated differently than independent contractors for purposes of employment protections, like leave laws or wage and hour protections. Or things like that. And also they're obviously very different for tax purposes. So all different agencies in the government are interested in making sure that companies are classifying people who are employees, in fact, as employees. And they're reserving that independent contractor status for those parties that are truly on a contract basis and are providing services through a contract. And how we make that determination will actually differ depending on the context that we're looking at. So that is one thing that makes it kind of complicated, is that you don't necessarily have one very, bright line rule to say this person is an employee, this person is an independent contractor. You need to look at all of the facts and circumstances surrounding the arrangement you have with them to see, are they acting more like an employee? Are you acting more like an employer with the level of control that you are exerting over their work, how they do it, when they do it, and things like that? Or is this truly more an independent party and you just have an agreement with them to do certain things, and then they make kind of the decisions on when am I going to do this, how am I going to do that, just to make sure that I'm complying with my contractual obligations. So it really looks at the issue of control to determine whether someone is an employee or independent contractor, even though the various tests for some of those purposes I talked about, like employment laws or tax issues, those can differ in their details. So here in the example that we mentioned, we have an auto dealer that was trying to expand its oversight of those dealer trade drivers that it's working with and implementing some additional operational requirements, having certain dress code requirements they want them to follow, without necessarily thinking about, is that additional control that I'm exercising, is it going to make this relationship more of an employment relationship, or will they still retain their status as independent contractors? So this is kind of an example of one situation where you're looking maybe very, narrowly at saying, well, these things can save money, or, we can be more efficient, or it will be great for branding for us if we can have everybody on board with these types of things. But it's ignoring a whole other piece of the situation that we do need to keep in mind. So we can accidentally have some, unintended consequences of some great ideas if we don't realize that they're, impacting another thing that we have to think about. So the solution that we have here is to make sure that if we are making those changes or we're wanting to have some additional requirements that we're imposing, that we look at that bigger picture, look at our larger goals, make sure that we are, not kind of accidentally limiting ourselves here or creating additional risk, because we still want to maintain those individuals and their independence, so that that independent contractor status can continue to be valid, and we're not running into issues down the road with, lawsuits from people who say, well, I'm an employee, so now you need to pay me this overtime, or you need to give me this paid leave, or, the tax, maybe we see the IRS come back and say, well, your tax returns are not correct because these people should have been employees. So those are things that definitely we want to avoid. And Robin, I think then I can turn this one back over to you for this number 5.
Thank you. Thanks, Erica. I was just thinking about another example that came in yesterday, actually, to our office, where a part-time housekeeper was hired to do some janitorial service, and it was a relative of one of the other employees. And they were paid as an independent contractor, acted like an independent contractor. But when they were let go, then they came back and claimed that they'd been misclassified. And there was some missing documentation because of the way the person got hired. So that's a perfect example, that unfortunately could happen to anybody. But moving on to the sexual harassment and discrimination slide that is in front of you now. Me Too and post-pandemic issues have somewhat collided. So one of the things that we really focus on here is, what can employers do today without spending extra money to try to reduce the risk of claims in these areas? And where are we seeing the claims? We are seeing some claims that relate to things like pre-employment drug testing, where employers are going back too far, or they're relying on drug testing around issues relating to cannabis, which may surprise you, especially since you're in an industry in which people drive cars. But one of the things that we have noticed a trend that we want to report to you, although I think it's too soon to completely endorse it, especially in your industry, and that is, if you are doing pre-employment drug testing, except for safety-sensitive positions, which would be, people who are actually driving, operating equipment, and that sort of thing, some employers are now asking that the 5-panel test not include the results of for any THC. The theory behind this is that that by including that portion of the panel, that employers will, on a large basis anyway, find that they have inadvertently discriminated against people of color, not just women, but people of color and certain particular identified groups. I don't know that there is hard scientific data, but there is some social data that the government is relying upon for that idea. And so if you are doing pre-employment drug testing, you need to know that there are these sort of currents and countercurrents out there. And there's some resources I'll talk about in a minute that can help guide you. Certainly, gender neutrality is an issue that creates what we think of as gotcha claims, where an employer isn't really trying to discriminate or not hire, for example, female employees to do jobs that in the employer's experience were traditionally more likely to be filled by men. But what can you do about that? It's easy. Review your job descriptions, review your offer letters, your dress code. Make sure that your independent contractor qualifications and advertisements and all are gender neutral and fit how your organization is doing business today. In maybe 5-10 years ago, it wasn't uncommon for a dress code for any organization, such as an auto dealer, to be 3 or 4 pages long. And the men's dress code was very different from the women's dress code. That was also true for many other types of businesses. But to the degree that you can simplify those things and take gender out of them, any step you take in that direction is a protective step that is helpful in terms of reducing the overall risk. This is also true relative to issues around age. Pregnancy, we're seeing a lot of what we think of as gotcha claims around issues of someone who went out on leave and now wants to come back but is making demands for flex time or a part-time schedule and things like that. Again, as I mentioned earlier, the interactive process is your best friend. We're also seeing some issues around pregnancy and COVID, which we'll probably address in a different webinar because of our time limitations today. We are seeing a lot more of employee expectations around issues of bereavement and the trend toward not being accountable to the employer for their time off. So we are seeing a number of employers who are going to, instead of having sick leave and bereavement leave and vacation time, just calling it all PTO. Not required by the law, but something we put out there for you to consider that might simplify your life a little bit. Also, it's a good idea to return to, as your organization is normalizing post-pandemic, regular training around issues of sexual harassment and discrimination. Why? Especially if your operations have been at all disrupted, you may need to gently remind even really valued employees of the rules of the road for your organization and the rules of the road as to what you're going to do for employees and outward facing as ambassadors of your organization. Also, if you've moved towards a more hub and spoke organization where you have centralized, management and HR resources and so forth that are being provided to a constellation of stores, all of which are either owned or partly owned by the same folks, these issues are very important to pay attention to so that you don't end up inadvertently increasing risk from one operation to the other. So with that, I want to make sure that you know, because we are brought to you today really courtesy of and powered by Federated. And as part of your Federated relationship, you have access to really great online risk management resources that are easy to use and can be accessed through MyShield. If you don't know how to do that, you can contact your representative and they will walk you through it. It's really, really easy to do. One of those services is a very robust question and resource facility that actually Erica is very deeply involved in, for which the login looks exactly like this slide here. And when you log into your Federated Employment Practices Network, you have access to all of the resources that Erica manages across the country. They are very robust and they have a very, very high use rate because they're so topical and easy to use. And they include things like a handbook builder and a lot of other tools that can really be a cost savings and but are actually just also really helpful and will save you lots of time. We recommend that people not try to do what we call a Frankenstein handbook. In other words, don't use your last employer's handbook and try to retrofit it, or go online and find 5 or 6 of them that you like and try to cobble them together. The problem when you do that is you'll end up with inconsistent terms, and that can create opportunities for people that want to make claims to try to exploit those. So I think we have a minute or so. I'm not seeing any questions. And here's the question panel. Oh, sorry, I wasn't familiar with this feature, so I just saw that. All right, what about you, Erica? Did any questions?
No, I don't see any questions here on this end, but I think if we have a minute left, Robin, I think it would be helpful to talk about one question that we had talked about recently that we have been running into with employers, having issues with staffing and potentially rehiring prior employees. And we had kind of seen it in an interesting light where someone had asked, should I rehire an employee who wasn't that great the first time they worked for me? So what are your thoughts on that topic?
Oh, well, yes, we are seeing a lot of that because employers are so challenged in finding good candidates, and because turnover seems to be at record rates. And so we are finding that employers are tempted to consider prior employees who left, what I think of as a no-fault basis, meaning they left for another job, they didn't leave, they weren't terminated, and they want to come back, but the employer is kind of lukewarm about them. Well, these are business decisions, and we always want to make sure that we don't step into the business owner's decision-making role or invade that, because that is not, that would not be, our job. Our job is to identify and array risk on a spectrum for the employer. So there could be times where that's not a terrible idea, but the risk factors include that the performance issues that manifested the first time, statistically, they're likely to come back. So I would say the best question to ask is, what has changed that would make this employee someone that you want to keep as opposed to someone you were glad that they left? Also, on an individual basis, you want to take a look at whether there were any unresolved issues that, if they're a bad actor, they want to perfect coming back. So maybe they left, a week before their 1-year anniversary, where they would have been entitled to other protections, either under the law or under your handbook or other benefits. Are they just trying to come back to get another bite at the apple? Those are going to be issues that you have to think about on an individual basis. So I would say, if I have to put it in really simple terms, that's a yellow flag situation. I don't think it would be fair to say never, but I would say proceed with caution if you're faced with that, and be realistic about whether that was someone you'd really want to have in your organization a year from now, 2 years from now, 5 years from now. So I hope that was helpful. Rachel, I'm going to pass it back to you because I think we're already 2 minutes over, and I want to be very respectful of everyone's time.
Robin, Erica, you shared some really important information that not everyone thinks of in the day-to-day things. So thank you very much for joining us. And thank you to Federated Insurance for sponsoring this webinar. Again, you will all be receiving a copy by the end of this week. To those on the line, join us back here on Tuesday, June 14th at 2 p.m. Eastern as Citron talks to the war for talent, how to compete in today's hyper-competitive labor market. So be on the lookout for promotions on how to register. For more information about AIADA, visit AIADA.org. Thanks for tuning in and have a great day, everyone.